Welcome to the chaos sector. As many know by now, O.J. Simpson had passed away recently. Although his life ended with a horrible reputation, he was a very influential figure not only in sports, but also had a bit of talent on the big screen. Many believed he was guilty, some believed he was framed, some didn't know what to think. Why are we bringing his trial up? Because it's very similar to the Idaho murders case. In fact, there is a key direct link with both, and everyone who has followed the chaos would know who that link is. That would be Mark Fuhrman. And the eerie element here is there was speculation that Mark Fuhrman, who was the leading detective in the O.J. Simpson investigation, had planted evidence at the crime scene to frame the defendant. In a deposition, Fuhrman, when asked about the allegation of planted evidence, he pleaded the fifth in response to that allegation. Of course, there was a legitimate reason for that response, such as legalities. But there was also the possibility that Fuhrman did not want to incriminate himself with any lead or trail of evidence that would be discovered based on a specific response. Of course, O.J. Simpson was found not guilty of the murder charges, and the nation was divided about the verdict. We will see the same result in the Kohberger verdict. Some will be satisfied with the verdict, and others will be outraged. We won't let Fuhrman lurk in the shadows. He resides in Idaho and was in fact a private investigator involved in this case. It's obvious he is one of the sources of many claims throughout the investigation. Think about the eerie comparison between both trials, with one person linked to both. What if Fuhrman had planted evidence to frame O.J. Simpson, yet failed? And fast forward decades later, and he has done something similar in the Idaho murders investigation, where it appears Kohberger has also been framed with planted evidence at the crime scene. Maybe he was the key player behind the scenes. It's certainly possible. Regardless of how you feel about the O.J. Simpson trial, Mark Fuhrman definitely cannot be trusted. It's safe to say that much of what the media reported as so-called evidence against Kohberger came from Fuhrman. And he would definitely be interacting with law enforcement, perhaps even was the private investigator for Kaylee's family. Public opinion is important, but in court, it is the evidence, or lack thereof, that determines one's fate. Now my colleagues don't feel the need to focus on the trial because they are investigating the case and continuing to put the pieces together. But I'm more focused on it, mainly due to the dialogue and even body language. Yes, the dialogue is important because how the prosecution, the defense, and the judge communicate with each other somewhat foreshadows how the trial will unfold. The problem with this trial is we have secrets, information, and, of course, evidence that is swirling around without being confirmed to exist. And that creates the mystery, or more so the suspicion, shrouding the trial's proceedings. Now let's examine an audio excerpt from Law and Crime.
Nothing that was done is worth the hysteria and the hyperbole that keeps getting expressed in this courtroom.
Bryan Kohberger's defense team pushing back against claims their survey of potential jurors violated a gag order and tainted the jury pool, while prosecutors cede no ground on the issue.
If it can't be done right, or if that's what it takes to do it right, then we need to do it. This is a big case. And the finger for this cannot be pointed at anybody but the defense.
Thanks for joining me for Crime Fix. I'm Anjanette Levy. Things are certainly heating up in Bryan Kohberger's case. Typically, things are pretty cordial between prosecutor Bill Thompson and Kohberger's defense attorney Ann Taylor. She actually worked for him many years ago. But things have changed a little bit and become more tense since the prosecution found out that the defense commissioned a survey of potential jurors in Latah County, Idaho. Kohberger has maintained his innocence in the murders of 4 University of Idaho students. Prosecutor Bill Thompson talked about the survey questions that were asked to the 400 residents in Latah County by phone. He claims those violated the court's non-dissemination order. They included things like, did you know Bryan Kohberger was arrested at his parents' house in Pennsylvania? Did you know DNA found on the knife sheath matched Bryan Kohberger?
And the state's position is that the fact-specific questions, and I understand from Dr. Edelman why the questions are asked. I understand his explanation. It doesn't change the fact that we have a non-dissemination order that specifically prohibits that kind of dissemination of facts, specific facts about this case.
Okay, the claim that the defense violated a non-dissemination order may be a valid objection at face value. But now we're getting into what information can be publicly released and what can't be. Mind you, this is also called a gag order, so apply this term to what was being disclosed to those 400 residents in the survey. Also, if we want to go by this non-dissemination order being violated by the defense, then we have a double standard from the prosecution. Let's continue though.
But there were questions that contained false information that really got the prosecutor mad, specifically when Bill Thompson cross-examined Dr. Brian Edelman, who's conducting the survey. Take a look.
You acknowledge false that Mr. Koberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
That Mr. Koberger allegedly stalked one of the victims.
Yes, I was trying not to say that because.
But you knew that was false.
I did.
So we learned something new there. A couple of media outlets had reported that Brian Koberger stalked one of the victims in the months before the murders. The prosecutor now says that's not true. But back to the issue at hand. The prosecution believes.
Now, here's the problem. Bill Thompson states that the claims of Koberger stalking those housemates were false, right? This is a very convoluted issue here, because if Thompson is in court claiming that claim is false, then he has just taken away a motive, which would be the most likely motive Koberger would have. In addition, we have to track the trail of information that reported this claim. As we all know, the mainstream media reported that Koberger had stalked one of those housemates. Of course, they didn't pluck this information out of thin air. They were provided this information. Now, who would have provided them this information? There are several sources. You have private investigators who allegedly discovered this evidence. You have the FBI and local and state authorities. My colleagues broke this down in the first series regarding the stalking claims. A private investigator cannot claim that the defendant stalked those housemates without this claim being reviewed or accepted by law enforcement as evidence. So, since law enforcement never claimed that Koberger stalked those housemates, how can a private investigator claim Koberger stalked housemates? Mind you, there was the claim that there was digital evidence to prove he stalked someone. Yet, if the prosecution is denying this claim, someone who is considered a law enforcement source, as described in reports, had disseminated key information about the defendant, and it wasn't true on top of that. So, what does this actually mean for the prosecution? It means they never prevented this claim from being disseminated out to the public about the defendant, and now they're interrogating the surveyor about it? I would suggest Bill Thompson is trying to accuse the surveyor of trying to paint the narrative that it is the prosecution that had claimed this, and he wanted to see what the potential jury pool thought about that claim. The problem with that is Thompson and his team never denied that claim up until this point. If I'm not mistaken, they actually allowed that very same false claim to not only be spewed in the mainstream media as reported evidence, but they never denied it in court also. So as long as it was generating the very same perception of Koberger being guilty from the public's view, the prosecution didn't have a problem with that claim. But when the surveyor posed these questions to a potential jury pool outside of Latah County, now the prosecution is claiming it's a false claim. A new jury pool is not biased in their perception of the defendant, at least in general. So when the surveyor posed these questions to that pool, their opinions about Koberger are based on what evidence has been provided, not based on a local perception of Koberger, who is depicted as an outsider who came into town and terrorized 4 college students. What I can already conclude from this exchange is the prosecution is a bit nervous that the perception of Koberger could be different from a jury pool outside of Latah County. Keep in mind, a jury of the defendant's peers doesn't mean age or relativity to the defendant. It means the defendant is given the right to be judged by a group of peers as equals. Equals meaning they are all human beings with the same rights, despite being charged for a murder. Innocent until proven guilty, of course. But in Latah County, Koberger would not be judged by a group of peers equally. Everyone knows that. It's obvious. A defendant is accused of murdering a group of young adults in a town they're not from, and the jury is composed of many from the same county that has the defendant in custody. They're guilty before opening statements. So the defense had a nice tactical chess move to check the temperature of the prosecution. And sure enough, they reacted to that survey in a very defensive manner. Defensive reactions indicate you have something to, well, defend. Isn't that Koberger's team responsibility? The irony. Also, I find it a bit odd that the host stated, quote, "But back to the issue at hand," unquote.
So we learned something new there. A couple of media outlets had reported that Brian Koberger stalked one of the victims in the months before the murders. The prosecutor now says that's not true. But back to the issue at hand.
As if the prosecution admitting that the stalking claims were false is a minor element in the case. It is more important than the actual exchange in this court setting. She sort of glossed over that, almost in a dismissive manner, right? Understand that if there is no evidence Koberger stalked anyone in that home, then the prosecution does not have a motive in regards to the lone killer narrative. If there is only one killer, then there has to be a direct motive they had. The motive is directly between that lone killer and their targets. And since there hasn't been a motive provided, and the prosecution is claiming the motive claimed was false, where is the plan being manifested from? Let's continue, though.
Dr. Edelman's methods tainted the jury pool and violated the gag order. Things got a little spicy.
And being told, watching on a Zoom, that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay, yes, it doesn't matter.
And please go ahead and be as angry as you like as you continue your work for the defense in this case.
So you probably detected a little sarcasm there from the prosecutor.
That's why they should relocate to another venue and even bring in more jury members from outside of Loudoun County. Thompson's dismissive attitude towards the frustration that the surveyor had tells us everything we need to know. He doesn't care about the frustration, just like he doesn't care about providing the defense with those 3 DNA male samples. And what about the genealogy expert, Gabriela Vargas, who the FBI somehow visited at her home? Because there were some so-called inconsistencies in her testimony? Oh, but instead of cross-examining Vargas in court about these alleged inconsistencies, Bill Thompson requested the FBI literally visit her at her home. Really? Who does that? I'll tell you who does that. A prosecutor who would use the FBI to intimidate Vargas and protect the truth of how they obtained Koberger's DNA, which is something the defense had been trying to get the prosecution to show. Ms. Vargas explained how there is a loophole in the genealogy testing, where you can basically edit information to match up DNA to a specific person. Could this be why the FBI visited her home, instead of the prosecution simply cross-examining her? That surely seems to be why the FBI would knock on her door. But let's continue.
The defense, meanwhile, fighting back against the claim that their expert violated that non-dissemination order.
We didn't violate the non-dissemination order. The information that now he's calling facts, it's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information, the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
But Judge John Judge said there were questions featured in the survey that included false information that may have been featured in media reports or on social media, but those were not discussed in an actual public document or record, and that concerned him.
I mean, those 2 questions were not in the public record. Okay. They were. I mean, they came out, but that was not the court. Where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client.
Again, going back to the source of the claim. The reason the judge is stuttering and having a hard time explaining where the claim came from.
But that was not the court. Where it came from.
Is because it came from law enforcement sources, which are private investigators. These private investigators work with law enforcement, helping solve cases, such as a murder investigation. Regardless if it's a part of a police report, evidence collected, or court documents, the actual investigative work of the private investigator is in partnership with law enforcement. If Moscow PD collected and reviewed surveillance from the neighbor's security camera and the Linda Lane surveillance, does the prosecution believe that the public wouldn't also believe that they reviewed that surveillance, going back months, to obtain the evidence that there was a motive for the defendant? And this is where the claim Koberger had been in that area 12 times prior came from, right? Who else would have reviewed that surveillance in depth in attempts to put together pieces? Oh, that's right, the FBI. And as we have always stated, the FBI is the key factor in this case because they're the, quote, gray area of mystery.
Let me expound on that a moment. If a private investigator claims Koberger had been near that home, or in that area 12 times prior, this would obviously be given to law enforcement. If they believe the suspect in custody is guilty of the crime, not only would they have the DNA, but also have the visual evidence that the suspect had been in that area also. They have all the evidence they need to convict, right? The DNA, video footage of prior visits, and even video footage from that very night of the crime. The prosecution could sit back in their chairs, and smell of triumph would cover the courtroom. It doesn't matter what the defense would say or do, they cannot explain all of the evidence against the defendant. Digital evidence of the defendant stalking the housemates online, video footage of the defendant in the neighborhood 12 times prior, video footage from that night, and to conclude it all, his DNA was found on a knife sheath in a victim's bedroom. We've heard about so-called miracles being performed by defense attorneys, but Taylor wouldn't be able to get Koberger out of that jam.
And Dr. Edelman explained that the information he included in his questions came from media reports and the affidavit filed in support of the murder charges, information that was already out in the public.
What I did, to be clear, is the standard practice in the industry, done hundreds of times in high-profile cases throughout this country. There's nothing I did to contaminate the jury pool. Everything I included was widely disseminated by the media in this county hundreds of times, if not more. And most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
It is not the surveyor's fault that these claims was made by the private investigator. The defense team is only presenting the, quote, false facts to the jury pool as a survey. And that's a great way to word the claim, a false fact. This is what the mainstream media had presented the entire time in this case. False facts. How about this false fact, since we use actual reports from Moscow PD? Moscow PD was searching for a 2011 to 2013 white Hyundai Elantra, yet ended up tracking a 2015 white Hyundai Elantra. What about the false fact that the prosecution hasn't identified the additional 3 male DNA samples and are somehow still waiting on the result? Or even mentioning Howard Blum or Blumenthal, there's a reason we call him that, by the way. Has Howard Blum been also criticized for presenting false facts? Because he claims the prosecution has certain evidence about Koberger and even claims that the surviving housemates were texting each other during the attacks and murders. But mind you, this claim is coming from what Moscow PD would have discovered, which was in turn provided to the prosecution. Now, this would have to be considered facts or evidence because there has to be a source of proof to claim it, right? Yet, once again, the prosecution never corrected this in court. He is claiming the prosecution has certain evidence. Shouldn't this be corrected?
I'll get you back to this update on Bryan Koberger's case in just a moment, but I want to take a moment to tell you about Sheath Underwear. It's a really great company. My husband absolutely loves Sheath because they make the most comfortable underwear he's ever worn. I mean, it feels like a soft cloud. I actually have a pair of them right here.
Now, I don't know about anyone else, but that does not seem to be a coincidence. I think it's a subliminal message. Sheath Underwear? Being promoted on Law and Crime? The sole evidence the prosecution has against Koberger is his alleged DNA on a knife sheath, and here is this host advertising underwear named Sheath? Remember, Law and Crime is also a part of the mainstream media, my friends. So don't forget that the very media claims the surveyor is addressing also came from this network as well. The network could have advertised anything else, especially not underwear, but underwear named Sheath? Come on, that's not by accident.
Alan Turkheimer is a jury consultant, and he has conducted these surveys in the past. So, Alan, what are your thoughts on the questions that Dr. Edelman asked to potential jurors?
I think he's doing what he wants to do to try to get the result that he's hoping to get. And that happens all the time. Maybe he pushed things a little too much and is testing the limits by having some questions in there that aren't necessarily true. But then again, from the defense perspective, it's not always about what is truthful. It's about what potential jurors believe. And if they believe something that's not truthful or that hasn't happened, they need to know about it. And I think that's the perspective he's taking with this survey and those questions that straddle the line of, did it really happen versus was it possibly reported that way?
He offered an explanation for why he had to put false information in there, and he said it was really to test bias.
Hold on, they're painting the wrong picture here. Stating, quote, had to put false information in there is alluding to the surveyor creating that false information. Yes, you have to listen closely to how things are worded. Instead of saying, quote, had to put false information in there, which suggests this was something that the surveyor manufactured, she should have stated, quote, the claims he placed in there, unquote. The claims are what had already been, well, claimed. Although the claims are considered false, which actually erases that motive by the way, describing it as false information instead of a claim indicates the surveyor himself is lying about the information. You see, it is not the surveyor creating false information, it is the surveyor presenting the false information that was created.
Now there is one key factor that was apparently addressed to the jury pool, which could be considered a violation of the non-dissemination order, and that would be asking the pool about the DNA on the knife sheath. But it's already established as evidence, meaning it's not under any non-disclosure order. I think what the prosecution is actually more agitated about is having new neighbors. Yeah, having a fresh set of eyes, ears, brains, and hearts somewhat purifies the overwhelming bias of the jury pool predominantly from Latah County.
The issue regarding the survey is more of a concern about outside jury pool members being potentially added to the grand jury. Adding these jury members increases the chances there will be different opinions and perspectives about the case, including perception of the defendant charged with the murders. Here's an example of how new jury members could potentially result in a hung jury. The jury discusses why there were 3 additional male DNA samples collected at the crime scene, yet those samples have never been identified. That is very important, because the jury would naturally wonder if those 3 males may have been involved in the crime, or how Moscow PD never provided the whereabouts, which would be an alibi, for one of the surviving housemates, who has already been scrutinized for not calling 911 for over 8 hours. And this is not even factoring the likelihood that she would be called in to testify based on her eyewitness accounts. The jury would start to question if this murder case is deeper than just the defendant being charged for those crimes. Combine this with the prosecution actually admitting that the stalking claims have not been confirmed or have not been claimed as evidence from them, the motive for the defendant becomes very mysterious, and jury members would start to scratch their heads about why would the defendant commit this crime without a confirmed motive. So the prosecution is more agitated with this having an impact in trial rather than some survey. They don't want the venue moved from Latah County because it's where all of the secrecy behind the murders resides.
Now, it's very clear, very clear that the prosecution wants this trial held in Latah County. They don't want this trial moved. So that's why they're having so much heartburn over there. So they're saying, well, really our issue is the fact that this violated the non-dissemination order. False information was put out there. The judge shared that concern. He said, we've tried to keep the noise out of this case. The prosecution is contending that is their concern at this point in time, whether or not this messed with the non-dissemination order. Your thoughts on that? Do you really think that crossed the line?
It's not about the survey, another deceptive tactic used to hide the prosecution's real concern. It's about balancing the scales of justice, and it definitely has not been balanced in Latah County.
That seems to be what's happening, and you can almost feel the nervousness from Bill Thompson as a result. They feel that if there is a change of venue, the defendant starts to slip from their grasp, which is already occurring in the venue they're currently proceeding in. It's not only a change of venue which creates almost a new outlook, but also the addition of potential jury members. The prosecution should have just provided the DNA samples of those 3 additional males, and at least it would have shown they are not attempting to conceal evidence. And if you want to talk about a double standard, we know the prosecution had those DNA results early on in the investigation, right along with the alleged Kobergers. Thompson stated they didn't have it to provide to the defense. Yet everyone in that courtroom, including the public viewing from the outside, knew those males were identified. If you talk the talk, the defense just wanted you to walk the walk. And to this point, the prosecution has been doing a lot of talking and taking baby steps, and I mean that literally. The defense is playing defense. They're in the position to challenge everything alleged by the prosecution. The defense inquires about the 3 additional males, and if the prosecution had provided actual identities, we would have another investigation, and the case against Koberger would at least for the moment be dismissed. Yet without those males being identified, or even more absurd, no results of those males coming back up until this point, now it appears the prosecution is actually, get this, protecting the identities of those males. Talk about a very sticky position to be in. But this is the jam they created for themselves, trying to protect the truth.
Yes, the truth behind the murders is known by the jury members mainly from Latah County. Everyone in that county knows the truth: grandparents, college students, of course, teachers, employees at businesses, radio hosts, local news stations, the mayor, the governor, and ultimately law enforcement. The town will obviously stick together, even if it means staying silent about the truth behind those murders. But for the prosecution, they have a tall task on their hands, even with their preferred jury pool, because you still have to provide the evidence against the defendant charged. And without the motive, you are relying on DNA, which the defendant early on stated wasn't his DNA. And I'll just go ahead and say it. Spoiler alert. This is the defense's game over chess move. They can prove it's not Kohberger's DNA, perhaps in several ways. Keep in mind, Bethany Funk is still a key witness from the defense's standpoint. They claim she has exculpatory evidence. Exculpatory evidence is not subjective, my friends. It's evidence that proves, yes, it proves that Kohberger didn't commit those murders. We've come to the conclusion that Bethany witnessed others who were there that night, which would more than likely be the killers. Which is why the prosecution is so apprehensive in providing the additional DNA samples of the other males at the crime scene. Because with that request, they know the defense has proof Kohberger was not there that night. And it brings us right back to the DNA found on the knife sheath, you see? Can you imagine being the prosecution's shoes right now? They have the burden of proof. The spotlight is on them to prove Kohberger is guilty, and we haven't even gotten to that point yet, and they are literally losing their composure. Nevertheless, I think the determining factor in trial will be the summoning of those surviving housemates to testify. That will provide the motive, eventually. This is the chaos sector.